Hi, welcome back to Finally Revealed. In this episode, this is kind of like part 2. I want to talk about the burden of proof in a criminal case. You are the jury and you are coming in to decide a case, and it is a criminal case. They are going to talk about the case at the beginning. They're going to present the evidence, and then at the end, the prosecutor is going to argue that they have proven whatever the charge is against the person on trial beyond a reasonable doubt. Most often, that's about all the prosecutor's going to say, if anything. Most likely they're going to say, look at this woman or this man, they did it, and we have proved that they did it. The defense is usually the part that's going to bring out beyond a reasonable doubt, because they're going to try to create doubt or show that they did create doubt, or that the prosecution failed to prove its case. So I thought it would be helpful to tell you about reasonable doubt and substantial evidence, because they go together and people don't talk about substantial evidence. So I thought that might be helpful. Now, you don't have to memorize this. As I said before, at the end of the trial, the jury is given in some fashion, either iPad or electronically or in paper, the jury instructions. They will carry you through all the way to the end of the trial. If you don't understand something in those instructions, ask a question. You can contact the bailiff, ask the bailiff to bring you evidence, ask the bailiff to give any clarification. And here's why I'm saying that in particular here. It applies across the board, but in particular here, it applies because the court doesn't have to explain to you or give you a definition of what beyond a reasonable doubt means. You might not be aware of that. They can give you a definition, but they don't have to. So if you have any question on any of the instructions, ask, because everyone wants you to understand what's happening and to make your best possible decision based upon the evidence that's presented. So while they don't have to give a definition, and they might not, many courts do. And here are a couple that the courts have given, and I'm going to have to read some of these because I can't memorize them, okay? Or I didn't memorize them. Okay, now every element of the crime has to be proven by beyond a reasonable doubt. So there will be instructions leading you through the elements of burglary, robbery, theft, murder, manslaughter. There will be either one big question or separate individual questions, and they will add up to the charge or no charge, okay? So one definition of beyond a reasonable doubt is proof that leaves one with an abiding conviction that the charge is true. That's the simplest one I found. Okay, that was the definition that was given by a court in what is beyond a reasonable doubt. While it's difficult to find a full explanation of beyond a reasonable doubt, there are cases where the court has said what reasonable doubt is. And here are those. One said, a reasonable doubt must be a real doubt. It may not be an imagined one, nor one that is manufactured to carry out an unpleasant responsibility. I thought that one was pretty good. Another one is, a reasonable doubt must fairly arise out of the evidence presented or out of a lack of evidence with respect to some element of each of the crimes charged. And then a longer one is, reasonable doubt is one based on reason, not mere possible doubt, but such a doubt as would govern or control a person in the more weighty affairs of life. In the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say that they feel an abiding conviction on the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. That one was a little longer. I think if you get to the end, that was a little bit better. Now, in telling the jury how to apply this standard or what is or is not reasonable doubt, the Supreme Court has said that it should be expressed in the terms of the kind of doubt that would make a person hesitate to act, and not be expressed in a way on the way that the person would be willing to act. So I don't know if that really helps you or not, but reasonable doubt is that makes you pull back. And it's got to be beyond a reasonable doubt so that you don't hesitate. You're comfortable going forward. Now, one thing that they don't talk about is substantial evidence. Each part that you find was beyond a reasonable doubt, if that's what you do find, has to be supported by substantial evidence. And that is evidence that a reasonable finder of fact could accept as adequate and sufficient. So it can't be just a feeling, oh, he looks guilty, or she looks guilty, or she doesn't look guilty. Because I've said in other videos, the judge is the arbiter of law. The jury decides the facts. So if the facts are supportive of the verdict, it will be adopted. If the facts do not support the jury's verdict, based as a matter of law, the judge can intervene, but usually they don't. So these standards have been around as long as our country has been around, and these are what you are going to measure the evidence on to see whether or not one side carried their burden or the other side created doubt. And that's how you decide the case. I hope this was helpful to you. If it was, or if you learned something, give me a thumbs up. If I've made it totally confusing, leave me a message below and I'll respond. Thanks so much for subscribing, and come back and see me next time. Thanks for watching.